Before I call the Honourable StephenLawrence, I want to acknowledge that with us here tonight, either in the galleries or I believe also watching in the Quarry Room, we have Chris Sabbs, Anna Brown, Ghassain Kassai, Tammy Vardone, Teddy Cook, Sam Johnson, Danielle Young, Noreen Shah, Tiffany Jones, Anna Van Brown, Emily Mulligan, plus LGBTQI community and supporters, and the members for Sydney and Newtown, and of course the Attorney-General. They're most welcome.
Thank you, Deputy President. I rise to speak in support of the Conversion Practices Ban Bill 2024. We have all received a deluge of emails and letters about this bill and related issues. This strength of feeling in the community is mirrored here, where I know there are strong and conflicting views. The bill represents a valiant attempt to balance the need to repudiate and prevent harmful conversion practices on one hand, and the need on the other to, 1, protect freedom of religion, 2, uphold the sanctity of communications and relationships within the family, 3, allow the medical profession to treat complex health issues with informed care and good judgment. I'm aware of the trauma associated with the historical and ongoing use of conversion practices, and I do think that we need to be mindful of that in our contributions, while of course we must also speak freely. I spoke this week to a friend of mine who was subjected to conversion therapy as a teenager back in 1967. He is a delightful human being, funny, intelligent, and now even able to see the dark humour in his own experiences. I'll read some of the notes from my conversation with Michael Tobin. Quote, "I object to the term conversion. What I experienced was all about aversion. They never actually offered the conversion part. It seemed to be aimed at making one asexual. When I was growing up, being gay didn't exist. When I decided I was gay, by that I mean attracted to males, I didn't want it. I wanted to be normal. As you get older, you discover that normal itself has 50 shades of grey. I went to Lifeline first. I was 19. It was 1967. They referred me to Neil McConaughey, at that time Australia's foremost expert in treating homosexuality. He took me at my word and decided I needed to be treated. I was at Prince Henry Hospital for a week in the psychiatric ward. That was deeply disturbing. It was full of acutely mentally ill people. I didn't consider myself to be crazy. The week converted me to not wanting to convert. Stage 1 of the aversion therapy involved showing me pictures of naked boys and men and females, early teens onwards. My penis was put in a tube, and if you became sufficiently erect, you got electrocuted. It wasn't painful at first, but an obvious electric shock. The whole process was so embarrassing. I come from a family, a typical Australian family, where nudity was off limits, and even discussion of matters sexual was a complete no-go area. Stage 2 was nausea-producing drugs. I opted out of that. After a week of being hospitalised and treated, I can say I became averse to aversion therapy. I remember consciously saying to myself I would rather be gay than asexual. A year later, I ran off and joined the theatre. Within 18 months, I had my first sexual experience, and it was so overwhelming I thought, wow, was I really trying to get away from this? From my experience, I would say you cannot change someone's sexuality. Neil McConaughey's daughter later put on the record that he himself was in fact same-sex attracted. I note that he later had an epiphany and became an expert proponent of sexuality in fact being unchangeable. End quote. That is a story about being subjected to conversion practices at a leading public hospital in this state in 1967. The past is indeed another country. Even more extreme forms of conversion and aversion therapy have been practiced in different places, including castration and the deliberate infliction of brain injury. I read that aversion therapies, like the one Michael experienced, had their roots in practices developed in Czechoslovakia, and different variations were carried out over a period of about 60 years in certain parts of the world. I read that they were rejected fairly early in the Eastern Bloc, with some early proponents in fact becoming advocates for decriminalisation of homosexuality, which occurred in Czechoslovakia far earlier than here. However, these practices were picked up in Commonwealth countries like Australia and systematically trialled for many years. Their eventual abandonment is dated to around 1973, when psychiatric bodies in several countries began to remove homosexual desire from their catalogues of mental disorders, of which the DSM was one example, or is one example. These systematic medicalised conversion practices are not, of course, the only types of conversion practices. Other types, which are still practiced today, are more informal and sometimes difficult to characterise, and whose banning potentially raises issues of religious freedom, including counselling, prayer-based sessions and the like. I quote from Amnesty International, quote, "These practices are often carried out in the context of pastoral care, prayer ministry, accountability groups, or in therapeutic context, such as counsellors or life coaches. Because of this, they can be often difficult to spot and rationalised by religious groups as providing care for unwanted same-sex desire, gender expression. However, conversion practices can be identified by their common beliefs in conversion ideology," end quote. I read that these modern conversion practices became more common as formal medical conversion practices were abandoned and have been most common in Protestant Christian church denominations, but that similar practices have also been carried out in other Christian and non-Christian faith groups. Australian studies indicate that people in Australia continue to be exposed to conversion practices. A 2019 study of 6,412 LGBTQA+ Australians under 25 found that 4%, 249, attended counselling, group work, interventions or programs aimed at changing or suppressing sexuality or gender identity. A qualitative study undertaken from 2016 of 42 Australian victim survivors found that 1/3 experienced conversion practices through formal therapy with a registered psychologist or counsellor, and every participant had experienced spiritual conversion practices. Personally, I speak on this bill remembering well the shame of being a gay kid that can drive consent to such procedures. I recall in the 1980s as a child fervently wishing not to be gay and praying to God that I might be changed. I remember that belief that there was something wrong with me and hoping it might just go away. But you come to know over time in your heart that it's just you, it's permanent, and it can't be fixed. Such shame is produced by a culture that can lead to family and others to in fact compel subjection to such procedures. An important thing about this bill is the message it sends to sexually and gender diverse kids. You are normal, you're absolutely fine as you are, you don't need to be fixed. And I can say to such kids as a gay person that I wouldn't change a thing about my very fortunate and privileged life. While it wasn't true as a child, I can say now in all honesty I wouldn't want to have been born straight because I wouldn't have the wonderful life and partner that I have. And I'm not sure if I'd have the 2 dogs or not. Indeed, I acknowledge that interjection. Section 3 of the bill is a cornerstone of the proposed scheme and defines a conversion practice as a practice, treatment or sustained effort that is directed to an individual on the basis of the individual's sexual orientation or gender identity and directed to changing or suppressing the individual's sexual orientation or gender identity. Section 5 then creates a criminal offence if a person provides or delivers a conversion practice to an individual with the intention of changing or suppressing the individual's sexual orientation or gender identity, and that causes mental or physical harm to the individual that endangers the individual's life or is substantial. I do want to discuss some of the concerns that have been raised with members by the community. One is what is said to be an inappropriate conflation of sexual orientation and gender identity as both being an immutable characteristic of a person and the consequences that might flow from such conflation. The question of immutability is relevant to anti-discrimination law and is a feature of American constitutional law with its concern about equal treatment. In Grimm and Gloucester County School Board, the Fourth Circuit Court of Appeals considered a transgender student's right to use a school bathroom that corresponded to his gender. The court had to decide whether transgender status was, quote, a class that may be defined as a discrete group by obvious immutable or distinguishing characteristics. The court held, quote, gender identity is formulated for most people at a very early age, and as our medical amici explain, being transgender is not a choice. Rather, it is as natural and immutable as being cisgender. The court did, however, limit this to, quote, the rights of transgender students who consistently, persistently and insistently express a binary gender, and stressed Grimm's immutable gender in the opinion, stating, for example, Grimm always knew that he was a boy and, quote, would opt to wear boys' clothing. Later, the court wrote that he did not question his gender identity at all. He knew he was a boy. It is commonly said and probably understood that sexual orientation is a generally immutable characteristic of a person, meaning an unchanging and fixed quality of a person. That said, I would not suggest that everyone is one way or the other, or that nobody has changes in their sexuality over the course of their life. Gender identity, on the other hand, is said to often lack that quality of immutability. It may be immutable, as demonstrated in the United States case I just referred to, but sometimes, perhaps often, it is said not to be so. It can shift over time. The research I have assessed seems to support these contentions that gender identity can be less immutable, that it can and often does change over the course of a person's life. There is a wealth of evidence. I note the Westmead Hospital has published statistics on the rate of desistance for young people diagnosed with gender dysphoria and assessed it at 9% and at 22% overall among those presenting with gender confusion and distress. This would seem to show that many young people, provided with the appropriate medical care, who identify as trans may not do so later in life. It obviously doesn't say anything about young people who identify as trans and don't seek gender-affirming treatment and their rate of desistance. One would assume that it may be higher. This in no way dismisses or undermines their right to identify as male or female and, of course, to be treated with respect. In any event, it must be stressed for many people their gender identity is fixed and immutable, just as described by that American court in Grimm. As part of the queer community, I've known many such people. I'm talking about trans people, whether or not they seek medical interventions and ultimately gender reassignment surgery, who know exactly what they are and always have, and it is not a gender consistent with their biological sex. I have, on the other hand, also known once trans people who no longer identify as such. The phenomena of desistance is a relevant thing to note in this debate because a large part of the community concern around trans issues at the moment is focused on the question of medical treatment of trans youth, in particular the use of puberty blockers and surgical interventions that in effect seek to align gender identity with sex. A concern being expressed is that trans youth will avail themselves of life-changing medical interventions in circumstances where they will later regret it and or where they would later, without the treatment, have assumed a gender identity consistent with their biological sex, i.e. that permanent medical treatment will be given at a time when a person being a child is less equipped to make decisions with long-term implications for a situation that is not in fact permanent but the effects of the treatment will be. Another concern is that there is said to be a lack of evidence that such early interventions, commonly referred to as the Dutch protocol, actually minimise the distressing symptoms of gender dysphoria in young people. The research on this seems to be evolving and conflicting. I do not recite these concerns to adopt them, and indeed the complexity of the medical and research issues make it difficult for me to form a certain view on some of these concerns. I raise them because these broader concerns feed into consideration of the bill in a few different ways. Firstly, there is a concern, again that has been expressed by community members, that the legislation itself adopts this premise of immutability in respect of both sexual orientation and gender identity. This is said to come firstly from the twinning of the concept of gender identity with the concept of sexual orientation, but also from the provisions in subsection 3 of section 3 in terms of what is excluded from the meaning of conversion practice. The concern, as I understand it, is that these exceptions and legislative examples seem to be premised on the idea that a person has one fixed gender identity that should not be challenged, even if a person can be assisted to explore it under the legislation. A part of the concerns being expressed is particularly that same-sex attracted youth might identify as trans and ultimately undergo medical interventions, when in fact, if given time, they might ultimately desist and identify as gay or something else. There is, of course, a close connection between gender and sexuality in a society that enforces both in a close and related way. The concern is being expressed particularly strongly in respect of young same-sex attracted people, perhaps with other conditions, that might make a diagnosis of gender dysphoria a more complex exercise, and which it is said might require greater exploration and may be challenged by medical professionals to determine the most effective form of care. A second concern being expressed is that this alleged legislative premise of immutability, or the fact of potential exposure to wrongful criminal prosecution, might impact the way in which the medical profession administers treatment for gender distress, confusion and dysphoria, i.e. that doctors, psychologists and psychiatrists might feel compelled to affirm a stated gender identity and prescribe medical treatment and proceed on the basis gender identity is immutable and once articulated must be affirmed, even if the professional, for example, is concerned the etymology of the articulation of the gender identity is something else, or on the other hand, be less likely to treat these conditions at all, as they will perceive a risk of complaints in circumstances where the line between legitimate exploration of identity might be fine and subjective. On the second concern, I think it is important to consider not just what a piece of legislation might say and what we think it in fact means, but also a range of uncertainties, not just in legal meaning, but how it will actually operate, what fields of operation it will have. I say that because our laws are not just normative propositions with a fixed meaning and effect. They operate in many and varied ways in the way they are both understood and enforced. It should be acknowledged, though, that these concerns and the debate they are part of does not occur in a vacuum. Many of these concerns, though not all, are being expressed by churches and faith-based organisations. Many are influenced, and proudly so, by theological, scripture-based principles and natural law philosophical precepts. I don't say that to dismiss their concerns, but it must be acknowledged that many voices in the debate do have that perspective. But not all the voices can be characterised in that way. There are medical professionals and professional groups also raising concerns who don't seem motivated in that way. There does seem to be a rapid increase in reports and diagnoses of gender dysphoria, and this, on my view, seems to be a new and evolving area of medical specialty. As I said, I find some of these issues and concerns hard to form a settled view on. However, I'm comfortable supporting the bill because of the clear exception to liability in Section 3, subsection 3, for a health service or treatment provided by a registered health practitioner that they have assessed as clinically appropriate in their reasonable professional judgment and which complies with all relevant legal, professional and ethical requirements. I note also the examples in Section 3, subsection 3, of what is not a conversion practice, including genuinely assisting an individual who is exploring the individual's sexual orientation or gender identity, or considering or undergoing a gender transition. 2, genuinely assisting an individual who is receiving care and treatment related to the individual's gender identity. And 3, genuinely advising an individual about the potential impacts of gender-affirming medical treatment. In my view, the exception in the examples make it clear, if clarity was needed, that a medical professional is not required to always affirm a professed gender identity, let alone required to prescribe significant medical treatment if not satisfied it is needed and in the best interests of the patient. While the risk of the section stifling a divergence of views in the medical profession or causing some professionals not to practice in the area because of a perceived risk of prosecution is concerning on its face, I understand the legislative examples have helped address concern, and I trust the consultation has occurred in a proper way. We ultimately need to trust our institutions of justice in how these laws are enforced, just like we need ultimately to trust our professions in how they will operate in the context of these laws. These issues fundamentally are between patients and doctors. That is the only way these complex issues can be worked out in the best possible way. And there is a real risk in not legislating. The evidence before us is that harmful conversion practices continue to occur. That is unacceptable. On that basis, I hope this bill is passed and that it works well, that it puts an end to conversion practices, and that it sends a powerful message to our diverse communities that they are indeed normal, accepted and respected. I commend the bill to the House.